which might be passed on to consumers. Could I ask what evidence there is of demand for multidisciplinary practices or one-stop shops, as some might refer to them?
I guess that's quite a difficult question to answer at the moment. We did issue a survey to our members, but unfortunately we only got an 8% response rate. From that response rate, the majority were in favour. However, at this stage, they're not fully familiar with what the regulatory impact is likely to be or the cost. So I think they are very much, looking to keep their options open and looking to see how this bill proceeds and what the regulatory impact on them will be.
So I appreciate that you're speaking today on behalf of your members. So the members, you haven't consulted widely with clients, for example, who might think it a good idea or not to be able to go to this one-stop shop.
You haven't taken it further than surveying client firms. Well, member firms, yes.
Okay, and that was 8% response. How many members do you have?
We surveyed almost 1,000 member firms.
Oh, so it was member firms?
Member firms, yes.
Okay. I think the professionals seem to be having difficulty in getting their members to respond. I think we had a similarly low response to a consultation by the Law Society. Anyway, to move on, in relation to the regulation of the multidisciplinary practice, does the bill provide a satisfactory framework for dealing with divergences and differences between respective professional standards and codes of conduct?
Yeah, I think the bill is very much an enabling bill, and we'll need to wait and see how the detail works out. As I said before, I think the bill does meet those requirements. I think what will be absolutely critical are what the obligations are on the approved regulator. The way I see it is they have to be at a fairly high level to allow the individual professions to continue to regulate the individual professions. That means that the conflicts can be dealt with quite easily, because it's really only where there is a conflict with the approved regulator obligations and what the licence provider has to do to satisfy the approved regulator that there would be difficulties. So I'm comfortable that the way the bill is structured at the moment, provided that the approved regulator's obligations are in such a way and structured in the correct way, then it would be okay.
And the document that you're going to supply to us, the one that you used for people applying for non-member registration, do you believe that can deal with the different, the conflicts that might arise through the different professionals and protect the integrity of the business being provided?
I think what you've got to remember in this is while they become a regulated non-member, they are still very much affiliated to their home institute, so they still have oversight by their home institute as well. So it's a way of bringing them in so we can monitor and look at various different aspects of the firm's work.
And could you perhaps explain, tell the committee how you believe that the multidisciplinary practice involving solicitors and accountants, how their differences might be reconciled?
I think the issue of conflict is one that has to be dealt with by each of the various institutes, and we all have various codes of practice and ethical guides that deal with our own conflicts of interest. The regulation of the individual professions will still continue. What we would have to do is sit down and look to see if there are any potential conflicts from an entity and licence provider perspective that we would have to address, but that could be done by way of memorandum of understanding. And we've already had some discussions with the Law Society to see that, well, that's quite a sensible approach.
Thank you. James Kelly.
Thank you, Convener. In previous evidence sessions, there's been concerns raised about the potential for undesirable third parties, getting involved in law firms as a result of this legislation. And In a previous answer to the convener, you cited the application process and the elements within that, which would provide some safeguards. If ICAS were to become an approved regulator, are you confident that the processes would be robust enough in order to stop undesirable third parties, getting involved?
Yes, certainly I think from our point of view, we have a very robust process of assessing whether people are fit and proper to become regulated in whatever area, for example, if they were coming into audit to be audit registered. That type of similar approach could be quite easily applied to this type of business setup to make sure all the necessary checks are put in place. And that would be very much a condition placed. That would be one of our obligations to make sure that happens, so that the provider has gone through a fit and proper process.
So how would the kind of checks flag up if, for example, somebody had previously been involved in criminal activity?
That would have to be declared on any form of application.
And if the person applying didn't declare that, is there any way of tracking it down? Essentially, you require knowing the honesty of the applicant.
We are relying on the honesty of the applicant. I think it will be very much dependent on the nature of the applicant, and if we feel we need to make further checks in that respect, then we would certainly do so.
So would you agree that, there's a potential problem there in that if some undesirable elements are entered in the application process and they're not entering it with an honest intention, they may not declare previous criminal convictions?
Yeah, we'd have to consider how we would safeguard against that. But yes, that is a consideration.
Okay. Just in terms of your submission, paragraphs 7 to 10, you raised some concerns about the branding of licensed legal services providers. I wonder if you can just elaborate on that a bit for the committee.
That comes back to the point I was making earlier, that I think if we have a firm that has primarily chartered accountants, for instance, and one or two solicitors, then I doubt if it serves the consumer interest well to say that they're legal services providers, because then I think you would assume that was a firm of solicitors rather than, say, primarily accountancy-related services plus some legal services. And as the bill's currently structured, it's a moot point, I think, as to whether the separate regulatory vehicle will be a legal services provider, or whether that is a kind of subtitle and we would be able to still refer to the firm as, say, chartered accountants and solicitors regulated as a legal services provider. But I can't imagine, for instance, that if we had a firm of chartered accountants who took in one solicitor, that they would be interested in adopting this kind of approach at the moment, because it wouldn't lend themselves to putting forth what they do.
Thank you. Nigel Dawn, please.
Well, thank you, Convener. And in fact, I just really wanted to continue that. In particular, I'd noted your comments about that before, and with regard to the head of legal services and his or her overriding sort of control, perhaps particularly of money, makes great sense that within a legal business somebody should be responsible for clients' money. But of course, accountants do that routinely. So I can quite see where you're coming from. I'm just wondering if you could give me some clues as to how that might really be resolved. Should the person who's responsible for the accounting mechanism for clients' money, which I think is often the important point, be either a CA or a qualified lawyer, or what's your resolution of that, do you think?
I don't see it as being a big issue whether it's a lawyer or a CA, as long as there is a professional designated person who's responsible for it.
Yeah, I think that's the size of it. Thank you.
Are there any other questions to this panel? That being the case, ladies, can I thank you very much indeed for giving your evidence this morning so clearly. And my apologies for the late start, but you do appreciate that the weather conditions are fairly exceptional. The committee will suspend briefly.